Notice and Take Down, hacia un modelo normativo en América Latina. Estanislao Mezzadri, gerente de legales para Hispanoamérica en Google Argentina. Juan Cichero, Brand Protection Manager en Epson America Inc., Argentina. Gonzalo Luzuriaga, gerente general en Luzuriaga y
Gonzalo Luzuriaga from Ecuador. Moderator, Virginia Servent, partner of Lex Atlas Guatemala.
Buenos días.
Good morning, everyone. It is a great pleasure to be again in another ASIPI Congress. It's a pleasure for me to share what we have done in panels like this and to talk about this topic that is notice and takedown. All of us have heard about notice and takedown, and we have had different countries with situations with free trade agreements with the U.S., but this is a dead letter, and we don't go forward with a procedure that is really effective to achieve a notice and takedown that will promote what we are trying to get. And we need them to have access to the regulations that we need, that is different situations against the networks, against with the fraud goods or false goods. We need a more efficient laws that can generate an immediate result to avoid having real damage, as happens with the contents of sporting events or live events. We are not able to put a break to real-time live transmission. The damage is already there, and we cannot do anything else than being sorry. So today we have a great panel. We have Gonzalo Luzuriaga, we have Juan. Juan, your name is complicated. Cichero, is that right? Gonzalo is representing the law firms that deal with these topics, and he will talk about these challenges and the things he has been able to achieve and difficult parts regarding notice and takedown. We also have Juan Cichero from Epson. He is the sales promoter of his brand in these online markets. And we also have Estanislao Mezzadri, also complicated surname, from Google, so that he can give us his point of view as a search engine that is so important for all of us, and what each of us from our trenches we are doing so that this notice and takedown is effective and can become reality that will allow us to put a break, to put a stop without any need to go in front of a judge, but through the cooperation of ISPs, internet service providers, that can make up a similar procedure, similar to the one we have in ANCA, but with our own rules, so that we should not download a content that has a license or an authorization. And because of the fact that we have not asked, we will download what we should not. So this procedure has a structure that should be used properly so that effectiveness will comply with the final goal, to meet the final goal, that is to put a break to the online false product content so that everybody has legitimate content, so that we can have this creativity and so that people know that they are providing a service that is attractive for the consumer and they will not lose in 2 minutes what they had to invest throughout the years. We also have the safe harbor, the topic that is confused, that I can upload whatever I want to, but this safe harbor means to have a system that will allow you to, if you are uploading your legitimate product, not to have somebody who will make use of that sale or that content to make use of this and going against your rights. So safe harbor will imply having a safe place for the headers and for the consumer, for the holders, owners of the information and the consumer. I hope this is useful to all of you. And then we will see how we can solve the issue about lack of procedures and what are the mechanisms that we can use from wherever we are. Just to start, we have the available participation of Gonzalo Luzuriaga. He will tell us what he has been able to do from Ecuador and as part of his region, within his region, to use an effective way to reduce these situations, these problems in the networks, even when we don't have a procedure in place. Welcome, Gonzalo. All yours.
Muchas gracias.
Thank you very much. Good morning, everybody. It is an honor for me to share this space with Virginia, Juan, Estanislao. And I would like to thank ASIPI for opening up these spaces from my professional trench. It is very important. My work on enforcement has been physically located in quite complicated territories as to protection of IP protection, IP rights protection. Many cases, this depends on the willingness of the administrative authorities, fiscal judges, and in many times, the lack of knowledge of the law has direct influence on the final results of these actions. I would like to propose to you a different framework, a notice and action, where not only we can eliminate illegal publications, but through the information and the technological tools that we have available to us, we can set, as legal advisors, global strategy against these infractors. All of us know that in our Latin American system, if we don't have a uniform law that will allow us to work in any way, we have situations where the legal regulations need requirements and a proof of the delinquency of the infraction. Though many actors have changed the platform, and we cannot yet act against them. The idea of this notice and action is to speak one same regional language that will allow us to get uniform frameworks of behavior against those who go against the law. Situations are not enough today. Several years ago, it was very important to recall falsified products, but today they are not the cure. When you deal with seizures, they are just a means. The strategy is to use this physical means of seizures and accompany them with strategies in the digital world. Takedowns are essential in each of these actions, and these are part of a global field. It's also important to complement the physical world, the digital world, with the incorporation that we have been able to collect throughout the time. Criminal organizations, we have realized that throughout action, they know us already. They know that many times who are the lawyers, the brands they represent, the trademarks, how they act frequently. And we try to have a global strike to the global organizations. I would like to tell you about some interesting cases that we have had that are graphically represented on what I'm trying to communicate here. Back in 2022, we had an interesting case. The Customs Office of Ecuador stopped a load from the south border to Ecuadorian territory. We were reported as banking representatives, and as soon as we received that information, we realized that this violator had been subject of different measures in the border a couple of years before. This was shared with the fiscals, and after some situations, we were able to identify not only the carrier, but this has changed the modus operandi, and they tried to evade control with this. These criminal organizations know how they have to deal with their illegal actions. Their storage was not located in Guayaquil. Legal authorities are very active. They put their storage in a city close to Guayaquil, a small they don't have activities, and from the satellite they brought the goods to trade them in a bigger city. After a coordinated interinstitutional action with the authorities, we were able to stop this criminal band, and the prosecutor changed the penal characteristic from IP to an illicit association in order to perpetrate an IP situation. This is today's message. As lawyers, I believe that our current model of seizure is finished, is over. We have to combine this with special other activities. Takedown sometimes is much more effective in social networks, more than falsified things. We destroy the identity of the suspect, but by means of operational intelligence, having something against the criminal strategy is much more effective. Through penal action, we can disarm or dismiss a structure that was dealing with the trading of those products and all the steps, smuggling, etc. This allows us to have a cost-efficient way to go against the violators. We have measures in the borders for importers, seizures for those who store the goods. We have alert letters, warning letters for the traders. So in this way, we attack each of the segments of a commercial illegal trade through these letters, warning letters. And we have been able to get information about their distributors, information through legal documents, affidavits that are used later to achieve a stronger case and a structure against the criminal organizations. At the end, this case is with a sentence against 6 violators on illicit association to perpetrate IP crimes. Unfortunately, in Ecuador, the sentence is 1 year. It should be much higher because of the This was a very interesting case in Ecuador because of these violations should be even bigger. The case of an importer has allowed us to have information on their supplier in a foreign country. This information was duly taken to court in the legal and penal research, and this was a foundation to be able to have actions in the foreign territory against the supplier. Not only being able to attack the product at local level, but also taking the process and research one step beyond, disassembling the whole organization and removing the product from its roots. My message today, beyond looking for new strategies, is to use the information that we set aside as part of our processes. The tools that we will listen to some of them now, some of the tools, digital tools that are available to us will allow us to identify organizations. Let's not do without that information. Let's not leave aside that information that comes from civil society. Let's use that information to build stronger, solid cases against the criminal structure, not only on a violation act. Latin America does not need to delete contents. We need a system that will disarm illicit economies, illegal economies, and ASIPI is a privileged place to discuss this situation. Thank you.
Gracias, Gonzalo.
Thank you, Gonzalo. That's not to finish late today. I will give the floor to Juan Cichero, who's going to talk about his experience as brand owner and brand protection, going from the Epson brand and all the infringement he has identified, and how he has been able to work things out in the media, and how he has been doing all these things for the company he's represented. Juan, the floor is yours. Thank you, Virginia, Gonzalo. I'd also like to thank ASIPI for having invited me. It's my first time here. I got the invitation. Gonzalo, thank you for inviting me. The bad thing is I missed paddle, because when I tried to register for the paddle activity, there was no more room. Well, I'm Juan Cichero. I've been with Epson for 3 years. Epson, for those of you who don't know this, is a Japanese company. The name is Seiko Epson Corporation. It started its operations in 1942 during the World War, manufacturing Seiko watches. I didn't know that Seiko was part of the Epson group, and they went to printers, projectors, and scanners. And they also manufacture industrial robots. Within our vertical industries, in our business, we have the home appliances line, well, for homes and small companies. Then we have printers for the commercial sector, and industrial printers, which are much bigger. And we work in different Latin American countries. I work for Epson America, which is a Seiko Epson affiliate from the U.S., based in Alamitos, close to L.A. And my role covers Latin America. There's a colleague of mine working in North America, U.S. and Canada. I work from Argentina all the way up to Mexico. And the main problem we have in Epson related to IP is consumables, inks, inputs, which accounts for a large share of our business, because even though we sell printers and other devices, we want users to stay close to our company, not only buying our products, but also our inputs. We face lots of challenges 25% of the ink business in Argentina happens online, so e-commerce is gaining a larger share of the market. In Brazil, our main business market, over 60% of the market of the business happens online. So you may imagine the volume of online transactions. This is no longer brick and mortar, but online gaining share. We are also seeing sophistication growing among salespeople. Salespeople are becoming smarter and trying to find a way so as not to be reported by brand owners. And they do this by using different means to hide the brands, even though the product they sell is a fake product, infringing our brands. They use multiple identities, even though some marketplaces already have systems to verify authenticity of users behind salespeople. There's still room for improvement, and that is an issue for us. Then there is also the dynamic nature of the business. Things are continuously changing, and we as brand owners, you as trademark representatives, have to go after those changes so as to try to capture offenders. And there is also something related to the different tools used in the online platforms so that brand owners can tackle the problems. There is a wide variety. Some tools are very basic, implying manual processes. In other cases, there are more sophisticated means with platform search engines. You can enter your rights and you can start reporting based on this. And this affects us in terms of report monitoring and migration to the social media. We see that salespeople are moving to the social media because it's more difficult to identify them. Taking down users in social media is different from marketplaces. And sometimes you also need to buy product, not only because it's requested by the marketplace so as to take down the illegal user content or for the sake of investigation. As Gonzalo said, taking down publication is a tool, is a means to take other actions eventually, such as investigations and prosecuting offenders offline in the field and trying to identify the manufacturing plant. We try to go to the point of origin. We're not tackling points of sale so much, except for some specific cases. This is what we see in our fight against this issue. And finally, in our industry, not only do we see simple and direct fake products, but you also see other products used by other printers that also infringe our rights. So it's not pure fake products, but products that in a way try to imitate our inks. So we've built quite an interesting strategy to tackle this problem. Thank you, Juan. And now, without further ado, I'll give the floor to Estanislao, who's going to talk about how they have tackled this issue from a very well-known search engine, which is the search engine most of us use to get to where we want to get. So what does Google do, and what's their responsibility? Because by the end of the day, Google is not an ISP. It's a search engine, a platform where we can find what we're looking for. So these challenges will be described by Estanislao. It's the challenges that brand owners or content owners may reach more easily through your platform so that more focus is placed on these things. Thank you, Estanislao, for being here with us, because it's very important to know what Google can do for us and what Google can also do for themselves to enforce their responsibility and carry out good practices.
Thank you very much, Virginia, Gonzalo, Juan, and ASIPI for the invitation. Market share of the search engine, when it's your opinion, Virginia. I believe all of you know Google. I will not introduce the company, but I think it's interesting to have a framework. Although, well, Google, the search engine, as Virginia said, this is one of the products or platforms among which for the public here, it's interesting. YouTube is the platform to share videos. Play is Google's App Store, Google Play, same as other products such as Google Maps, ads for announcements for advertising platforms, and others. Just to understand Google's position in general terms, it's important to remember the mission of the company, that is to organize world global information so that it's universally useful and accessible. This is what sets the north, the goal of all our developments. And this is a mission that will require a legal framework that will reinforce the freedom of speech in both dimensions, individual, so that everybody can express themselves, but the social one that implies access to information. Evidently, this has to do in balance with many other rights, among them intellectual property, IP. As Virginia just said, the responsibility of the middleman, the one that applies to Google and its products, is not a permit to facilitate violations of IP or any other illegal actions. Specifically, another important point that I would like to state here is that Google and the search engine or other products are ISPs. They are not ISPs. And this is important when we think about notice and takedown, because of the action that can be required from these platforms. The ISPs are the ones that can block sites, websites, so that they cannot be reached. What Google can do is to remove content from some of the platforms. This does not mean that it won't be accessible by other products of the competitors, other search engines, or different platforms, or other app stores. Specifically, we need to set a difference in the fact that Google products are not social networks. YouTube is not, and it's important when we think about notice and takedown. This is not just terminology. The effect is quite different. The blocking of IP from a search engine that can do the indexing. This can facilitate or can be between user and internet content by means of the different robots that will see the different contents, different pages, the pages that can be indexed. Of course, a website can decide by means of an easy protocol not to be indexed and not to appear on the search engine. What the search engine can do is, and we will see what type, why this can be removed, that is to remove a specific content. But the search engine cannot participate, cannot have an intervention in the website, as ISPs might block DNS, or maybe blockings of IPs also, or dynamic blockings. But this is the universe of the ISPs. If we get into the intermediary ISPs, internet, Google basically, if we remove content, we will do for either violation of their policies or for legal reasons, one of these two reasons. Each Google product has its own policies, and one is a search engine, YouTube, Play, and they respond to the different natures of the platforms. Probably YouTube tries to generate a community. They are more robust than the search engine, where the intention is to show information that is available on the internet. Or in the case of Google Play, that is a market of applications. There should be clear rules, but the intervention is not on the applications. These policies are global policies, and the goal is to reflect consensus, global consensus, and not to have concepts that depend on the jurisdiction where we are. A typical case would be children, pornography, sexual abuse, sexual harassment for children. These are in general terms, we will agree on that. This ranges from privacy issues to make a content that can reflect the spirit of the YouTube community, for example. Then legal reasons, among which violations to IP violations. In that case, Google's system, with the differences in different products, will show the AMCA and notice and takedown that will record this legislation. Platforms, when faced with certain claims or jurisdictions, will also serve legal requirements of that jurisdiction as long as they are applicable. So, Google has different web forms for the different products, through which a content that is violated, that is IP violation, can be reported. When that notice is implemented, it has to be as detailed as possible. It has to meet the requirements fulfill the requirements of IMCA, and the content has to be well identified by means of the URL. As to Play, ideally the URL of the application or the package ID, that is a denomination system. In the case of YouTube video, instead of the video, for example, if you want to report some advertising, the URL of that advertising. You have to clearly state the right they are going against or they are violating, and the one who is raising the claim could be identifying whether it's the head or a representative, and we need to identify how this is being violated, how the content is being violated. Somebody from Google will check this in our region. The service provider in Hispanoamerica is Google LG, located in US. It has global teams that devote to checking these requests, these forms. If they check this, if there's a violation, actions will be taken. And as much as possible, and depending on the platform and the regulations, this will be reported to those who are responsible for that content. And they will have the possibility to introduce a counter notification. If they do so, in that case, those who submitted the claim will have to show that actions were implemented against those who uploaded the content that go against their rights. There's a very important point here if we think about the concept of this panel, that is notice and takedown, and the possibility of setting a legal framework in the region. It is very important to think who want to determine the illegality of content. There are clear cases, and this could be patent related to cases that we start with a gray area, and there's abuse, and the platforms need to take this into account, because this is a forum where quite likely a platform such as Google will receive claims or more action on certain violations, but in forum related to freedom of speech or human rights, the submission we have to do with having voices with excuse of IP. So evidently, some balance is required. Also, it's important to know who determines with the violation. Google does not want to become a judge or not to decide on that when there's a violation. Justice has a role. This can be debated, of course. Google will set certain actions by means of Google notice and takedown, but in those cases where the violation is clear. And now, referring to the framework, the possibility of notice and takedown framework in our countries. Evidently, although in our region we share one same legal culture, law on IP, there's similar culture, not all legislations are the same. There are exceptions that can be foreseen in certain legislations or others, and this could make a more homogeneous system more difficult to achieve. But I believe that the intermediary responsibilities, starting with the U.S. with the 2030 in Safe Harbor, the commerce concepts in European Union, Brazil now, Maria Belén Rodriguez in Argentina. There's jurisprudence in Latin America. I'm not wrong, in Chile, the law on intellectual property has some articles related to Safe Harbor, but in a process, notice and takedown procedure, well, I believe it's important. So when it comes to thinking about this kind of projects, we have to take into account the role of middlemen on internet and freedom of speech on internet, and considering intermediary responsibility and those who have no responsibility for third parties. That's where participation starts. When there's a system of notice and takedown, we need to notify on some illicit actions, on some actions to be taken. This is part of the debate that we wanted to introduce. I wanted to introduce these preliminary concepts to see the position of the company and the possibilities of going forward with a similar system, considering that today we have good results on this practice. Thank you.
Gracias, Estanislao.
Thank you, Estanislao. You mentioned a very important thing, and you mentioned the term de-index or unindex. For those of us who have been in the online production world and who have tried to take down unauthorized content, de-indexing is a well-known term, but I'm sure it's not quite common to everyone. Well, we talk about taking down the index. We talk about browsers as synonym. De-indexing means that a certain content will no longer be available through our browser and will not appear as a result of a search. So I will not be able to access that through the browser, but I may access that through a specific URL, through a browser or another search engine, because even though it's true that Google may be the most widely used search engine, there are other browsers from other companies, and de-indexing it in one search engine does not mean that it will be de-indexed in others. And it does not mean that I will not be able to access that directly if I had a specific URL. Because with a browser, I do not have to find something using the exact URL. I write some terms, and through an algorithm, I get a set of results where I can find what I was trying to find. So de-indexing means that if we no longer appear in the browser, it will not be offered as a result for a search. Gonzalo, when you mentioned notice and action, in the notice and takedown, In order to have an effective notice and action in Ecuador, in Mercosur, or in your region, how can you implement this notice and action when you are facing, for example, content piracy? Thank you, Virginia, for your question. Notice and action means leaving behind the idea that seizures or takedowns are enough. They're good analgesic, but they're no longer the cure. In practice, every day we see that infringers change locations, platforms, names after legal actions, and our actions are not enough. Notice and action aims at having a global strategy that will cover all aspects to capture infringers so that we can get information that will help us to carry out action against the whole criminal organization. Thank you, Gonzalo. Juan, in your case, which are the best practices you have built to protect the rights of your brand online? Well, we have a work strategy that covers several aspects. First of all, prioritization. We have to understand which are the main operators in the illegal product sales market. Cooperation. If you had me here in this panel 10 years ago, my message would have been different. I would have said that e-trade platforms were the word that they generated illegal products, say that only fake products were sold. My position is quite the opposite today. The platforms have become the brand's strategic partner. They're no longer the enemy. Sometimes customers will say, I will work with these people. I will do business. So they're no longer the enemy. We have to find a way to cooperate and work together. I was in both sides. I worked in the marketplace and in the other sector. And many of you, well, already know this. This is not new to you. So cooperation is key. Getting closer to the marketplace. If we have cooperation agreements, we contribute information, we hold regular meetings with them. We suggest solutions or alternatives to tackle the problem or suggestions to improve it, because there's always room for improvement. Obviously, it's not that everything is right, but our goal is to work jointly with them. Then awareness campaigns for the end users to understand that buying alternative generic or fake products will affect our products, warranties, everything you may imagine. Another important topic from a business point of view is metrics. We should be able to measure what we're doing. You may do a great job, or you may believe you're doing a great job, but then when you go and talk to the business people, your internal customers, they may say, hey, but the real market share in this country is down. We have to go up 5 points. What are you going to do? And following up the metrics is key. We have to talk to the business sector to see what our real market share is, where we can find improvement opportunities, which are the countries where we can tackle this problem the best. So following the metrics and working hand in hand with the business. And finally, and more in line with the topic of this panel and intellectual property, is being creative. We have to try and see how we can tackle the problem by strengthening the brand portfolio and the intellectual property right. Over the past few years, we have really focused on trying to find those brands which are not part of our portfolio, but that can help us a lot in our fight against fake products. In the case of Ecuador, we got very good results by registering brands that were not our main brands in our portfolio, but that were assets we wanted to protect, and we were able to start to tackle the problem. because in the past people would say, well, this is fake products. But if we have a more robust portfolio that we can use for enforcement, that will help us. In the case of Peru, we did quite well over the past few years in terms of these more creative brands so as to cover other products. And I have an example of the tridimensional brand. We have been able to register tridimensional marks in some markets. The design of the bottle, we use a bottle. Coca-Cola may have its own unique bottle. In Epson, we have a bottle design that is quite unique and that's being replicated by several players. And this is helping us in some countries to tackle this problem. So I would say that's a piece of advice or something that has worked for us at Epson. Work with your customers and be creative. We have to think out of the box and say, well, if this is your portfolio, which other brands or marks can we include, or what other assets can we protect so as to fight the problem in a more comprehensive way? This is what has worked well for us. Thank you, Juan. When I mentioned notice and takedown and the commitment we have in many countries to create a procedure that will help us have an effective notice and takedown. In our free trade agreements and treaties, there's a section about restriction of liability of intermediaries. And this implies, that is, it mentions ISPs directly, but it also mentions intermediary and defines who the intermediary players are in this digital world. And that's where Google comes to play as an intermediary. That is, intermediary means you can get 2x through my platform. That is, through their business, people can reach a certain place that may or may not be legitimate. That's where we have this idea of the safe harbor, which is not opening up the door to everything that looks like, but knowing that in the case of child pornography, for example, that's banned everywhere. You don't even have to prove it because it's quite clear. This is the ultimate goal of brand owners, content owners. That is, would like to say it's clear that this is my content, and if I'm saying that you're not authorized or this is not my trademark, we should be able to reach intermediaries, and intermediaries, as you said, Estanislao, should have a way to restrict this without infringing anyone's right. So it's important to know what Google mechanisms are, Google as an intermediary, to promote a real safe harbor in your platform.
Gracias, Virginia.
Thank you, Virginia.
Acá no le voy a...
I will not explain to you the number of different situations that may arise in a conflict due to infringement on IP. There are cases, clear cases of piracy, somebody who wants to sell a product pretending it's a different one. Well, these would be easier cases. Or it could be clearer, but there are other cases, as the one you mentioned, of licensees. We could also think of parallel imports, exceptions that foresee, some legislation foresee as to the use of brands or trademark or IP in general terms. So there are many things that cannot be headed by the middleman to solve. So that's why, though, when faced with this situation, this statement, we have to do the analysis. If we see any violation and infringement, a clear violation, then the caveat as to third-party rights is to take action and notify those who uploaded the content. But this possibility is not there in all platforms. So in one case is YouTube, where somebody uploaded the video, or Play, the search engine is more difficult in general terms when Google indexes pages, the websites does not have any contact with the headers. Google Console will give you the possibility of receiving a notification and have a counter notification. In that case, when faced with a situation of the supposed criminal, the action will be taken that could be remotion. In the case of the offender, when you give me the tools, if you give me tools, a vision about partners and the head of rights and platforms, we are increasingly getting more into internet, and during pandemic, this was increased in YouTube platform. You look for this kind of platforms, and they have the heads of the owners of the rights. There are different tools that will allow you to match content. Well, what we said before, we need content to do content per content. In YouTube, they have different tools that will be available that fulfilling certain requirements, but they will allow to automatically match their protected content with what users will upload, giving different possibilities to the video to be removed or to monetize this for them or in a joint way. And different tools have been developed. Live events are a problem. They are very difficult to work on. We work on something, but there are other tools such as Content ID. We heard about it. This, by means of certain rights, you will be able to identify when something is being shown in a video, protected content, and the action will be direct. So we have tools. I believe the idea of partnership is very important. Of course, it will depend on the case. It will be easier or not so easy. Sometimes we can resort to justice. In our case, notice and takedown, we can gain time. Because clearly a big difference between offline and online, to put it somehow, is the speed and the exponential capacity it has of an infringement or a violation to become exponential. So it's important to keep developing these kind of tools. Thank you, Estanislao. Also, we have seen, as part of our Latin American region, the problems that we face in the case of we have this lack with procedures of notice and a takedown, and we have notice and action where based on the current legal system, how we can defend the rights of our customers as lawyers, and in the case of they are infringed through the networks, and how we can use what we have at hand available so that ISPs, because notice and takedown means notification and removal. Many times, takedown is not easy, so we need an access blocking. So judges need to have clear in mind what the DNS is, what the IP address is, what URL is, in order to know how to organize the decision, the ruling. That's what we do in Guatemala. In order to block access, it's not to take down literally, but it's to block access to certain websites that evidently will imply a constant work, continuous work, because you will block an access and a new one will come out. So what have you done as a company by means of the regulations that you have to be able to put a break, put a stop to the continuous infringement of content through the networks, having the tools that you have available today as a region and as a country? Thank you, Virginia. I believe we should start from understanding that offenders operate in a mirror situation in a physical world and in the digital world. We need to understand that the digital world will become a map of a legal strategy. And when we act in the physical and digital worlds, the offenders have a place where to hide by means of the social media and marketplace. We have been able to identify routes of the false products, transportation, distributors, trade people going against all the organization that we understand is a positive result for our customers. And we need to use all these digital tools for this purpose is very good. Do you believe that an important part is the willingness of the customer to be able to fight against piracy? Because many times digital piracy in the field of markets of products is easy to measure, but regarding digital content, it's difficult to measure because we don't know how many users we have in it in a legitimate website, and not always it's the same movie or the same soccer match. So it's hard to measure, and for the owner of a content owner, it will be difficult to understand what this will be in the long term, and actions will not be easy. However, Epson has a good way to measure because you are selling the products directly to the customer. So how does Epson, the question is, Epson activates the mechanism of fighting against piracy, of falsification of the sale of online false products. If you are active, if I will go for everything, zero tolerance, how do you make sure that you can define what you will go after and what you will not? We have only 8 minutes. We thought we would be faster, but it's hard. I believe, as I said before, the essential thing, in my opinion, is to prioritize. You cannot tackle everything. Internet is endless, so you have to prioritize. With the business, you have to define the priorities, the most important markets, where business opportunities are, what is the percentage of genuine market share, and the idea is to sit down and understand what priorities are. You cannot tackle everything. As a case of success, from online to offline, we had a recent case in Brazil where we investigated for 8 months different groups that operated different platforms, and thanks to that research, we were able to seizure 3 different cities at the same time, and to seize different goods, including machinery, different finished products, supplies, for 1 million units in 4 different warehouses. So we can do the job. It is not easy, but you can do it. Thank you, Juan. I believe we have finished with the questions. We want to give you the chance to ask our panel members whatever you may need to know about this procedure. If you have any doubt, if you have any question, microphones are open for you. Question there. Thank you for your presentations. Clear, complex topic. The question is, have you had any questioning or confrontation as to the procedure to have access with antitrust topics? Because when you proceed with a takedown, you're favoring one of the parties. I don't know if you could hear the question well. Can you hear better? The question is if you have had any experience in this procedure based on the needs and requirements to proceed. If you do the takedown, you're somehow taking a position in favor of one of the parties. And if this generates problems from the antitrust point of view or another point of view parallel to IP. I believe the question goes to me, I believe. I can start at least. The question is very interesting. At least in my experience and as part of the region that I cover with Google, that is Hispanic America, we have not had cases of antitrust or competition because of takedowns on IP. But there have been situations, especially on human rights organizations related to freedom of speech, because there's abusive situations. There's not much discussion as to the cases where there's IP violations, but there have been cases where abusive questioning has arisen, and we need to take them down for other reasons. So maybe the attention is placed mainly there. That's why I was highlighting the importance of not putting this at the heads of the platforms of the middlemen or ISPs. They are private companies when you have to determine the violation. A system that does not choose takedown, this has to be foreseen. I believe in the American system, this you have the possibility of those who started the action to appeal, but then you have it will depend on the responsible exercise that each one will perform when it comes to exercising or implementing the system.
Por favor. Go ahead. Hello, thank you for this interesting panel. I am Rodrigo Velasco from Chile. I have a question, a more political question for Juan, but what caught my attention is that you said that maybe the world of controversy between brand owners and e-commerce owners had come to an end, and that basically they are business partners. In Chile, at least, we're still seeing a lot of controversies between Mercado Libre, for example, and Alibaba, even VACC. Alibaba was the official sponsor. Many people would switch their badge ribbons because sometimes these programs transfer to brand owners the whole administrative work of taking down all the links to sell a service. I will offer our service through the official site, but platforms such as Shame, Alibaba, and even Mercado Libre are still making money, significant amount of money, by selling fake products. And in the case of Meta in Chile, we've just seen a case between Nestle and Meta's marketplace. They're using certain trademarks, for example, chocolate brand, to sell drug or psychotropics. And again, the brand owner says we have a great brand protection program. We have this URL for every product, and you have to fill in a form and take down. And you're able to take down the links 36 hours after several tons of drugs have been sold. Are you still seeing this in your experience? Well, thank you for your question. Maybe you misunderstood my message. Obviously, the challenge is still there. This is why I have a job, and so do you. But what I'm saying is that the focus or the paradigm is more collaboration-based. As I've already said, there are several differences among the different marketplaces. The procedure to report claims go from very basic to very complex, which is also a disadvantage. But we have to keep tackling this. Obviously, I agree with you, and I've just said that we had a significant seizure in Brazil. It's super complex, but I think we also have to consider that in several cases they are our partners, and this was not the case in the past, and everything was illegal in the past. We can continue with this discussion offline, but the message I wanted to communicate. Any other questions? We have time for just one more question. Otherwise, thank you very much, everyone. And we hope this has been a good panel for you. And I also like to thank the members of our panel for sharing their information with us.